Welcome friends. Today I am going to talk on 7 lamps of advocacy in the subject legal professional ethics. There are 7 lamps of advocacy: the lamp of honesty, the lamp of courage, the lamp of industry, the lamp of wit, lamp of eloquence, lamp of judgment, and the lamp of fellowship. These lamps that we are going to study in today's session, let us begin with. Let us begin with the 7 lamps of advocacy, guiding principles for effective legal advocacy. So there are 7 lamps of advocacy, and there are 7 lamps of advocacy: the lamp of honesty, lamp of courage, lamp of industry, lamp of wit, lamp of eloquence, lamp of judgment, and the lamp of fellowship, quoted by Edward Abbott Perry. So, first lamp is a lamp of honesty. Honesty is the best policy. Advocate cannot justice upon altar or justice. The advocate must keep his 7 lamps clean, burning brightly. In the center of these must ever be the lamp of honesty. The honesty is the best policy, and honesty brings the confidence and the courage while doing the arguments in the court of law. It also establishes the logical reasoning, and thing is that the truth cannot be remembered, the truth cannot be memorized like a false statement. False statement we have to memorize many times, but the truth is always truth, so that cannot be memorized. So truth is comes only when the honesty is there. So the great advocate is like an actor. So he must be a good actor, and he must represent his client in an efficient manner, and he must be a forceful in his argument. And the forceful argument only when will come when he is a true and he is a clear cut in his thinking and the logical reasoning. He fills the stage of for his span of life and succeeds the gains or applause, makes his last bow and till the curtain falls, just like a theater or a cinema. So as soon as the curtain falls, he must be memorized. His argument must be memorized, and he must be remembered what he is talked in the before the court of law. Nothing is so elusive as the art of acting, unless indeed it be sister or art of advocacy. The student of advocacy can draw inspiration and hope from the stored up experience of his elders. He can trace in the plan and the life chart of the ancient the paths along which he strode and the journey. They can be seen pacing the ancient halls with their clients and proud of the traditions of the great profession advocates and advocates are. There is a quote here that as a noble as virtue, far back in the capitalists and the charming, it was obtained of the profession of advocates that nobody should be admitted therein but the man mild, pacific, fearing of God, and the loving justice upon pain, elimination, so make it continue, world without the end. Then Englishmen have understood that the advocacy is necessary to justice. Honesty is essential to the advocacy. Unless there is honesty, the advocate cannot plead his case in a right manner. So every pleader who acts in the business of another, he should have regard for the 4 things. Number 1, he or she should be a person receivable in the court. He must be accountable to the client, to the other fellow advocates, and before the court. Second one, every pleader is bound by oath that he will not knowingly maintain or defend the wrong falsehood. He will not make any false statement, or he will not make any false affidavit before the court, and he will not misguide his client. Every pleader will never have a recourse to false delay or the false witness. So he will not produce the false witnesses, and similarly he will not make the unnecessary delays to the court. And there is a salary concerning which 4 points must be regarded: the amount of the matter in the dispute, the labor of the sergeant, his values as a pleader in respect of his learning, eloquence, repute, and lastly the usage of the court. The second lamp is the lamp of courage. Advocacy needs the king becoming a graces, devotion, patience, courage for the attitude. He must be courageous advocate because he has to face many complicated things before the court. Sometimes he has to stood before the hardcore criminals or hardcore or the influential people. So he must have courage to put forward his argument in forceful manner and in the courageous manner before the court. Remember, it is better to be strong and wrong than the weak and right. So he must be strong than the weak and the right. So he must be strong and the forceful. Whatever he speaks or whatever he spell out in the court, it must be strong and it must be have some concrete base of his for his argument. The belief that the success in advocacy can be attained by the influence apart from the personal qualification is ill-founded. It is true that the learning, vision, courage, and wise self-confidence can only founded on the knowledge. The knowledge is power, and when the opportunity arrives, the knowledge and the courage is used to effectively proclaim the presence of advocate. The knowledge, continuous reading, and the continuous deliberation of the argument in the mind. It is a continuous process that brings the courage to the advocate. There have been many advocates whose courage was founded on humor. He must be humorous because only the clever advocates will have a humor. That is the general observation. That humor brings a healthy environment in the court and gives the relief to the tensions and the complicated situations and the strong arguments or hyper arguments rather than the knowledge who have successfully asserted their independence in the face of the impatient and overbearing the bench through the medium of wit where the mere wisdom might have failed in the effect. Next lamp is the industry. All the great advocates tell us that they have had either steady habits of industry or the grand outburst of the work. Charles Russell had a continuous spate of energy, that is, do something, always do something. It is a continuous process of doing something. The first of task of advocate is to learn to labor and to wait. He must have good patience, and there never was a successful advocate who did not owe some of his power to the industry. The advocacy is indeed the life of industry, and each new success brings the greater toil. An advocate must study his or herself brief in the same way that an actor studies or actress studies their part or their role in the film or in the theater. Success in the advocacy is not arrived by an intuition. It is a continuous process of thinking and the logical reasoning and continuous sequence of the events. The Silverton Finch advises that the student, whatever you study in the morning, that should be spelled out in the court in the afternoon. For bare reading, without the practice, makes the student, but never makes him or her a clever lawyer. It should be recognized that the sitting in the court to listen to the conduct of cases, attendance at circuit mess, and dining in the hall, where the law talks of the senior may still on the occasion of values. That always gives a value addition to the junior advocates. All these things are in the form of the industry. The continuous discussion with the senior advocates and the continuous hearing of the arguments in the court of law brings always a value addition to the young lawyers or the junior lawyers. Next lamp is the lamp of wit. Good advocacy displays the highest form of wit in an instinct of brevity. The healthy appetite of judges and the advocate life is shown in a keenness. The word wit lies in the idea of knowledge, understanding, and sense which look for keen perception of some incongruity of the moment. The murky atmosphere of the court is illuminated by a flash of thought, quick and happy and even amusing. The wit wisely used bridges over the difficulty, smooths away the annoyance, or perhaps turns sides the angers, dissolving the embarrassment of the second laughter. So the argument must be in a healthy manner. It must be sometimes it may crack some humor or it may be some amusing to just relax the atmosphere and to overcome the hyper arguments before the court of law. The wit is often the fittest instrument with which to destroy the bubble of the bombast. The wit and courtesy needs never be diverse, they must go hand in hand, and indeed the complementary. Wit and deftly used refreshes the spirit of the weary judge. Satire or irony is often in the danger of the being misunderstood by the self-minded jury. Ridicule to be effective must be pointed, even extravagant. Next lamp is the lamp of eloquence. Eloquence is addressed to the heart rather than the brain. Rather than the brain. They gain the heart or you gain nothing. The eyes and the ears are only the road to the heart. So keep your eyes and ears open and see whatever happens before the court or before the you and whatever comes before you in the form of evidences, paperwork or in digital form. So that must be perceived in your mind and that is the only road to the heart. The flame of the lamp of eloquence may vary from time to time and heart and color. It may vary from person to person and advocate to advocate also. And what the judges interpret, that is also depend on the flame of the lamp of eloquence. The taste of eloquence in advocacy is necessarily its effect upon those to whom it is addressed. The aim of eloquence is the persuasion, and no one is absolute right in his way or wrong in another way. It is the perhaps it should say the appearance of the sincerity. One cannot say the style of one advocate is correct and another is incorrect. Everyone is correct by his own values and by own his judgment and by own his logical reasoning and the conclusions. Since the style of attribute of the man and the generation that he is trying to pursue. The Charles Russell did not seek the pursuit, he directed the court and jury. He was undoubtedly the very great advocate. Clearness, force, and earnestness were the basic qualities of his eloquence. It was said that it was said of him that the ordinarily the judge dominates the juries and the concept, but in this case he used to dominate the judges and the Russell dominates the everyone. So this is the required quality of the advocate that the argument must be forceful, correct, and judicious, and it must be impressive. Even the judge must give a clear-cut indication for his judgment. Then the lamp of judgment. The two golden rules are there. That is, never ask a question without having a good reason to assign for asking it. And second rule is never hazard a critical question without having a good ground to believe that the answer will be in your favor. So answer may be in my favor or it may not be in my favor, but it must be accepted and it must be welcomed. Judgment inspires a man to translate a good sense into right action. The judgment of the advocate must be based on the maxim. He that the judges without the informing himself to the utmost that he is capable cannot be acquit himself of the judging the amiss. A client is entitled to the independent judgment of the advocate. Whether his judgment is right or wrong, it is the duty of the advocate to place at his disposal and disposal of his client. The judgment of an advocate may be called upon by any moment for the sudden decision that may mean the victory or the defeat of his client. For this reason, it is necessary that he should be always alert. The contents of his brief must be already in his mind and his attention must be fixed on what happening in the court, which has rarely been foreseen in the best prepared brief ever delivered to the council. Watch the case is the golden rule. Not only watch the case, analyze the case and have a logical reasoning of the case, find out some points from the case and draw your own conclusion from the case. So this is the golden rule for the lamp of judgment. Make your judgment own and convince the court. That is the golden rule. Then lamp of fellowship. So collaborative effort, community oriented practice, ethical responsibility, unity with fellow advocates, broader social impact, and fostering trust and integrity. So these are the minor lamps of the lamp of fellowship. So first, the collaborative effort, the lamp of fellowship would remind the advocates to work as a team with the fellow legal professional experts, activists, and clients. These things I have elaborated in cooperation and the team making in the legal professional ethics. You can watch the playlist of my channel, that is professional ethics. So these things are given in elaborated form, that is cooperation and the team building. Then community oriented practice, the lamp of fellowship. In this context, it would suggest that the advocate must understand the needs and values of the concern of the communities as they represent. Then the ethical responsibility, the fellowship here also refers to the ethical obligations advocates owe to the society to uphold the justice and maintain the integrity in practice. The unity with fellow advocates, the law firms, advocacy groups, and the non-profit organization thrives on the collaboration of minds that contribute a diverse perspective and expertise. The broader social impact, the lamp of fellowship calls on the advocates to be mindful how their actions, cases, and the legal strategy will influence the society in the long run. Many judgments are there, the landmark judgments before the society, and society can take the inspiration from such judgments. And court also takes some precedence for this of this landmark judgment. Advocates must act with the understanding of how their work shapes the law and justice, social justice movement for the years to come, fostering the trust and integrity. It would encourage advocates to build the relationship based on the trust, integrity, and ensuring the transparency in communication, fair representation, and a commitment to their clients' best interest. So these are the 7 lamps that we have studied, and the separation of powers. Already we have studied these things in the constitution law. In Indian constitution, there are the 3 branches of the government that make, enforce, and interpret the law. Under the separation of the powers, each branch of government has unique function. Below show the different branches, their main functions, and the examples of union and state rules. So first branch is the legislative branch, which passes the laws, makes the policy frameworks, repeals the laws or abolish some laws and make new laws. So all these the responsibility are raised with the assembly in the case of state government and parliament in case of the central government. Recently, the 3 laws of this criminal, that is BNSS and Sakshi Adhiniyam, these are the passed by the parliament. And Moka and this RERA, Maharera, they are passed by the assembly of the Maharashtra state. So these are the roles of the legislative branch of the state government and the central government, assembly and parliamentary respectively. The next branch is the executive branch, the IAS officer, IPS officer, IRS officer, this category, and their hierarchy of officers. They are the executive branch. They carries out the laws, runs the government day to day. They are the executors. They are the executors, and they are implementation of or the implementers of the laws and the legislation. For example, the traffic Havaldar, he implements the Motor Vehicle Act. So this is the executive branch. The bureaucracy acts on behalf of the governor in case of state government and president in case of the central government. Whatever the tender notice you find out by the government, so they called by on behalf of governor in case of state government. On behalf of governor, the state of Maharashtra invites the tender. So this notice you must have seen in some newspaper. Or on behalf of president, the central government invites some LOI, or that is letter of intent, on behalf of president, or the tender notices on behalf of president. So this is the role of central government. And the judicial branch, this is they are interprets the laws in case of dispute. So they just go and interprets the laws and settle the arguments. High court in case of the state government, for example Maharashtra and Goa, there is a high court at Mumbai, and Supreme Court is apex court located at the Delhi. And High Court, they do have the benches at Aurangabad and Nagpur in case of the Maharashtra state and the Goa. Similarly, the Madhya Pradesh, they have own High Court. Gujarat, they have own High Court at Ahmedabad. And for Uttar Pradesh, there is a High Court at Allahabad. Likewise, there are so many union states, and they do have their high courts and their jurisdiction. And Supreme Court is a apex court located at Delhi. Then the check and balance. All the three. One more thing I have forgotten here. There is a fourth branch also. Fourth branch, which is independent branch, that is media. Sometimes you must have seen the media trials that is by TV channels or in social media. So this is independent, but this has nothing to do with the power. They don't have any power. They only have the independent opinion, and they are just like a watchdogs. They just observe the things and puts before the people, or puts before the citizens through the channels, TV or newspaper. So this fourth estate or the fourth branch we also call as the media branch, but they have no powers. They are just observers, and whatever they observe, they just mention either by TV channels or in the form of news, in case or some analysis on the different social media platforms, or some editorial in the newspapers. Then the check and balance. Each of these branches established in the separation of powers has power to check and control the powers of the other branches. So no one is stronger and no one is weaker. All the three branches, they are independent and they are strong at their own foundation. And but only thing is that no one should encroach the other branch. The legislative branch should not interfere in the executive branch. Executive branch should not interfere in the legislative branch, or the judicial should not supersede the legislative branch or the executive branch. They are independent and they must go hand in hand, rather than making some chaos and ultraviolence. These separations prohibits one branch of the government from becoming too powerful. So therefore, there is check and balance mentioned in the Constitution. The individual rights. So these are elaborated well in the Indian Constitution. We have our own freedom rights guaranteed in the Indian Constitution. That is Article number 14, 16, 17, 18, 19, 20, 21, 27, 31. All these are the rights outlined, include the freedom of speech, religion, press, and due process within the courts. These rights cannot be taken away. So this is the peculiarity of our Indian Constitution. So Indian Constitution is a great constitution, and admired by almost all the countries of this universe. Thank you, gentlemen and ladies. Today we'll stop here, and we'll meet some other time for the next session. Thank you.